Elon Musk reached out to OpenAI President Greg Brockman with a settlement feeler 2 days before walking into federal court to sue him. Musk fired off the message on April 25th. Trial opened on April 28th, and a new court filing made public this morning shows the exchange happened, shows how it went sideways, and exposes a side of Musk's case that the jury has not been allowed to see. If a settlement was sitting on the table 48 hours before opening arguments, what changed in that room that put Elon Musk on the witness chair instead? Now we're going to walk through the exact message Musk sent after Brockman tried to meet him halfway, the judge's ruling that kept it away from the jury, and the prediction market collapse that has pushed Musk's odds of winning to the lowest point of the trial, and the cross-examination thread where Musk's own sworn statements from a past lawsuit got pulled out and used against him. Everything traces back to one text. Now we'll get right into that right after this very short break. Now the Musk versus OpenAI trial in Oakland just took a very sharp turn that did not happen on the witness stand. OpenAI's lawyers filed a motion late Sunday night that quoted private text messages between Musk and Brockman from days before trial. The filing argued the text should be admitted as evidence. Now, the judge, Yvonne Gonzalez-Rogers, ruled against admitting them, but the contents are now part of the public record. Here is what the filing says happened. Musk messaged Brockman to gauge interest in a settlement. Now, Brockman wrote back proposing a clean off-ramp where both sides dropped their respective claims, and Musk then sent this exact line quoted verbatim in the OpenAI filing, and he said, "By the end of this week, you and Sam will be the most hated men in America. If you insist, so it will be." Now, there's two messages here. There's a negotiation, and then it turned into a threat. OpenAI's lawyers argued the exchange goes to motive and bias, and specifically that Musk's real goal in this lawsuit is to attack a competitor. And the judge denied OpenAI's request to submit the messages as evidence. Her reasoning was procedural rather than substantive. She told OpenAI's attorneys they should have introduced the text during Musk's 3 days of testimony last week, not after he stepped down from the stand, though. Now, Musk's attorney did not respond to a request for our comment, and the jury will not see the messages, but anyone reading court documents can read everything. Now, the reason this filing carries weight beyond the courtroom is that Musk is asking the court what to do. His lawsuit demands roughly $134 billion in damages from OpenAI and Microsoft, the unwinding of OpenAI's for-profit structure, and the removal of Sam Altman and Brockman from the board, and a court order making OpenAI's technology publicly available. He's framed this as a charitable trust case, arguing he was deceived into donating roughly $38 million to a nonprofit that turned into an $850 billion company. Judge Rogers has already trimmed the case at the pretrial stage, dismissing the fraud-related counts and leaving Musk with breach of charitable trust and unjust enrichment as his remaining theories. Both are tougher to prove than a clean fraud claim, which is part of why the settlement or else text matters as a window into intent. And OpenAI's countersuit argues the opposite of Musk's narrative, contending that Musk was supportive of a for-profit structure when he could control it and turn hostile only after losing that fight. Now, I've been digging into the analytics of the show and noticed that 37% of you are actually following this channel, and I am forever grateful for you. Thank you. The other 63% haven't hit the follow or the subscribe button. Now, I've been an independent journalist covering Elon Musk, spaceflight, technology, and AI for the last 6 years, and I'm going to continue for the next 10 years because of you. And all I ask from you is 1 second of your time, and you hit the follow or subscribe button on whatever platform you're watching or listening on right now. I'm extremely grateful for you, and I'm blessed to have you as part of this community. So thank you so much. Now, this settlement message lands inside a trial that was already moving against Musk in the betting markets. Kalshi traders priced his odds of winning at about 36%. On Monday morning, the lowest probability since the trial began, the contract entered the trial pricing Musk near 60%, dropped to 53%, and after his first day in testimony, slid to 39% after the cross-examination heated up Wednesday and is now settled at 36%. By the way, we're not any part of Kalshi. We don't do that on this channel, so it's not sponsored. Now, these prediction markets aggregate cash positions and update on every filing. So the move from 60 to 36% in about a week reads as a cumulative reaction to evidence the jury has heard. So Microsoft's lawyers ran a separate angle that fits into the same picture here. Russell Cohen handled Microsoft's cross-examination on the fourth day, and his strategy was to use Musk's own prior sworn testimony as a pinning device. Cohen got Musk to confirm that he had previously testified in earlier cases that he was literal and said what he meant in his public statements. That admission lets the defense walk into closing arguments and read any past Musk tweet or quote into the record under the standard Musk himself set under oath. The framing connects directly to the filing released today. If Musk meant what he said in his old depositions, then he also meant the line about Brockman and Altman becoming the most hated men in America. And the cross-examination playbook gets sharper once you actually know the lawyers. William Savitt, OpenAI's lead counsel from Wachtel Lipton, is the same attorney who represented Twitter against Musk in 2022 takeover litigations. Musk's record from that fight is full of dramatic on-the-record statements about world events, geopolitical risk, and corporate strategy that Savitt spent months collecting under oath. The body of testimony does not disappear when Musk shows up in a different courtroom 3 years later. It's the same stuff. Savitt has now used Musk's literal framing twice, first in Twitter, now in OpenAI, and the result is that almost everything Musk has ever said in a deposition can be cited back at him. Old statements have a long lifetime, and the internet never forgets. The pieces of OpenAI's defense fit together cleanly when you line them all up. Lead counsel William Savitt opened the trial telling the jury that Musk filed this case because he did not get his way at OpenAI and is now competing against it through xAI. Savitt got Musk to admit on the stand that xAI partly distilled OpenAI's models to train its own systems, which violates OpenAI's terms of service. Savitt also got Musk to acknowledge he tried to fold OpenAI into Tesla in 2018, walked away when that failed, and never delivered the $1 billion he had pledged. Settlement or else text from April 25th is the same pattern in compressed form: demand, pushback, and then threaten people. Now, the competitive dynamics also shape why the timing of this trial favors Musk strategically. XIM merged into SpaceX in February at a combined valuation of about $1.2 trillion. And the merged entity is targeting an IPO in June-ish at a valuation of roughly $1.75 trillion. OpenAI is moving toward its own IPO at a target of about $1 trillion. And a delay or restructuring order against OpenAI would land in the middle of that race. Musk's lawsuit asked the court to make OpenAI's technology available to the public and to strip Microsoft's licensing agreement away from them. Both remedies would directly slow the company that xAI is trying to overtake before its own listing. OpenAI's countersuit, filed alongside the defense, alleged Musk and xAI interfered with OpenAI's relations with investors, customers, and employees, which is the legal version of the same competitive logic. Now, the trial continues. Brockman, Altman, and former chief scientist are all expected to testify in the coming weeks, with the Microsoft CEO Satya Nadella also on this witness list. Altman said on the Core Memory podcast last month that he was worried that Musk would drop the case right before the trial, leaving OpenAI without a chance to put its side of the events on the record under oath. And the settlement text from April 25th fits that fear exactly. Stuart Russell, the UC Berkeley computer scientist whose textbook is the standard reference for AI safety, will testify as Musk's only AI expert witness, though Judge Rogers has barred him from quantifying extinction risk or talking about catastrophic outcomes in numerical terms. The remedies phase, if Musk's case clears the liability phase, is scheduled to begin May 18th with new time allocations for each party. OpenAI's IPO at a target valuation near $1 trillion is also hovering around in the background, which gives both sides a strong reason to push this trial to a verdict rather than to hold on to it and fold it late. Now, Musk has asked OpenAI to settle 2 days before trial. Brockman, doing the nice thing, said, "Hey man, let's settle this. It's okay, let's both drop it." Musk didn't like it. He told Brockman and Altman they'll be the most hated men in America by the end of the week. And OpenAI tried to put those texts in front of a jury. The judge said no. And now people think that Musk might lose. Let me know what you think. Do you think in the comments down below that Musk is going to lose this one? Or do you think OpenAI is going to uncover some dirt on Musk? Or is Musk going to uncover some dirt on Sam Altman in OpenAI? Take care, everybody. I'll see you in the next one.